Mọi người ơi, mọi người thấy được slide chưa mọi người? Thầy ơi, thầy thấy được slide không thầy?
Rồi, thấy rõ luôn nha.
Dạ. Vậy em bắt đầu nha thầy.
Ok, xin mời nhé.
Hello everyone, I'm a representative of Group 4 and our topic today is about specific cases of compensation for damage. And let's move to the first part, is compensation for damage caused by act beyond the limit of legitimate self-defense. And the first countries we want to discuss is Vietnam. And in Article 594, compensation for damage caused by the act beyond the limit of legitimate self-defense, it regulated that a person who causes damage in case of legitimate self-defense is not required to compensate the victim. And the person who acts beyond the limit of legitimate self-defense and causes damage shall compensate the victim. And according to Article 594, the person who causes damage in case of legitimate self-defense is not required to compensate the damage suffered. On the contrary, if the damage is resulting from the act beyond the limit of legitimate self-defense, the person who conducts that behavior is in charge of compensating for damage caused. And the Vietnamese Civil Code amended and supplemented in 2017 have not defined legitimate self-defense and act beyond the limit of legitimate self-defense, but we can refer to the provision in Article 22 of the Penal Code amended and supplemented in 2017. And the regulation is that the legitimate defense is the act of the person in order to protect his or her legitimate right or interest, to order or the interest of the state, an agency or organization, and to fight back in the necessary way against the person who is committing the act infringing on the above interest. Legitimate self-defense is not a crime. And the second paragraph is exceeding the limit of legitimate defense in an act of resistance. That's clearly excessively necessary and inconsistent with the natures and level of dangers to society and the Appeals Act. People whose action exceeds the limit of legitimate defense shall be held criminally responsible according to the provision of this code. Behavior that caused damage in cases of legitimate defense is considered lawful and not subject to compensation. And such regulation has significant legal and practical implications in protecting the interests of the state, the public, and oneself, encouraging individuals to engage in positive action in the defense of these interests. However, to prevent the abuse of legitimate defense to cause harm to others, civil law stipulate the individuals who cause damage to existing legitimate defense must compensate the injured party. However, determining what constitutes exercise force is not quantifiable and relies on the subjective discretion on the combating state authority. And such decisions are not subjective and rely on the discretion of the resolver. First, requiring not only specialized knowledge, but also impartiality, objective, and fairness. Because determining whether an action is legitimate defense or excessive force has significant legal implication. It also affects the determination or liability for damages and other legal issue. So to be considered legitimate defense, we have three main reasons. Firstly, the act of resisting is an act of resisting at the necessary level of act that are directly infringing upon their legitimate interest, infringing upon the interest of the state, public interest, or the performer. The defense act only need to prove that the act that is infringing on before mentioned interest. It is necessary to act like that, otherwise they say infringement will cause more serious damage or damage if no action is taken. That resistance. And secondly, damage causing act must be act that are directly infringing upon their own legitimate interest, the state public interest, or the interest of order. First, subject are technically infringing upon the interests of the subjects protected by the law, and limitation of legitimate act or defense in order to prevent the damage of a aforementioned subject. And lastly, such damage is not only the right and legitimate interest of the person who has resisted, while it is also in the interest of the state, public interest, and interest of other subject. The regulation of such act is intended to encourage subjects to perform positive acts, fight against illegal art, and infringe upon the interests of subjects in society, ensure social order and safety, and ensure the right to live in peace and provide for by the Constitution. And we can understand that behavior beyond the limit of legitimate defense is a subject misjudgment in the necessity of the behavior. It is against the law to commit act beyond the necessary level. Therefore, the act of defending beyond the limit of causing damage must be compensated. Exceeding the limit of legitimate defense must be compensated in order to ensure the principle that the right and the interests of subject must be protected by the law, and that all subjects are equal. It's regulated in Article 3, Article 11 of the Civil Code. And next two countries will present by one.
And now we will move to French. French law does not use the term self-defense, but recognize defense. However, the term self-defense will be used for the sake of convenience. Self-defense is not much discussion in French tort law, as it typically comes up in a criminal case. Victims of crimes have the option of bringing the tort law in the form of a civil action from the conduct where before the criminal court. Self-defense is usually used in the context of the criminal. Self-defense is defined in the penal code. It is not power should be considered a part of liability and civil.
Because of some problems, so it will take over the one part. So it will describe the French law also. French law does not use the term self-defense, but recognize legitimate defense. However, the term self-defense will be used for the sake of convenience. Self-defense is not much discussed in French tort law literatures, as it typically comes up in criminal cases. Victims of crimes have the option of bringing their tort claim in the form of civil action, as distinguished from the conduct by the prosecutor before the criminal court. Self-defense is usually discussed in the context of criminal proceeding. Self-defense is defined in the penal code, and this is no longer a justification, but a part to the liability. Eliminating all criminal and civil liability, whether based on false and other fact of a thing. So move to Germany law. Under the German civil law, the principle of legitimate self-defense allows individuals to protect themselves and their property from unlawful attack. Specifically in paragraph number 2, section 227, German Civil Code, regulated that self-defense is that defense required to ward up, present, unlawful assault on oneself or other. However, this right is not absolute and must be exercised within the boundary, proportionality, and necessity. Based on Paragraph 1, Section 227, an act required for self-defense is not unlawful. There must not be an extreme imbalance between the defended right and chosen method of defense. This means that the force used in the self-defense must be proportionate to the threat posed, and it should only be employed and necessary to repel the attack. In German civil law, compensation for damage caused by act beyond the limit of legitimate self-defense is governed by the principle of tort law. If a person exceeds the limit of legitimate self-defense and cause damage to another person or their property, they may be held liable for their action. The interest party can seek compensation for the harm suffered by filing a claim based on the principle of tort law, but they would need to demonstrate that the other person action were excessive and they suffer harm as a result. The court would then assess the evidence and determine the appropriate amount of compensations based on the principle of tort law. In Section 823, German Civil Court liability and compensations for damage, and you guys can see on the slide. To establish a claim for compensation, the interest party plaintiffs must demonstrate the following element, and that is three main elements. First, we have to follow the flow. The defendant must have to acted intentionally and negligently. Intentional act refer to situation where the defendant deliberately and exceeded the limit of self-defense. Negligence occur when the defendant failed to exercise the required standard of care in their action. And the second element is damage. The plaintiff must prove that they have suffered actual harm as a result of defendant action. This can include the physical injuries, property damage, or other losses. And the last one is causation. There must be a causal link between the defendant action and the harm suffered by the plaintiff. In other words, it must be established that the damage was a direct result and the defendant exceeding the limit of legitimate self-defense. If these elements are successfully proven, the court will assess the extent of the damage and determine the appropriate compensation to be awarded. The compensation aims to restore the injured party to the position that would have been in had the damage not occur. It can cover various types of losses, such as the medical expense, property repair costs, loss, weight, and pain or suffering. However, it's important to note that legal situation can be complex, and the application of that law can vary depending on the specific circumstances and the court interpretation. So move to the conclusion. According to some analysis indicated above, we can draw a general conclusion. Regarding to Vietnamese law, the responsibility of the compensation for damages caused by existing legitimate defense is relatively clearly stipulated in the Civil Code 215 and specifically in the article number 594. And the responsibility of the compensating damages in the legal system of French and Germany is not clearly defined as the Vietnamese law also. And the legal framework, not contractual damages in these two countries, hardly discusses directly to the cases of damages caused by the action assisting legitimate defense, meaning there are no specific provision recognize such cases. By combining the provision of civil code and criminal codes in France and Germany, if a person exceeds the limit of legitimate defense and cause harm to other or their property, they may be held responsible for their action, and the interest party can request compensation for damages by submitting a compensation claim. The court will assess the extent of the damage and determine the appropriate level of compensation. So the second part will present that one.
Now we will move to part 2. It's about compensation for damage caused by acts beyond the requirements of emergency circumstances. First, we will have Vietnam, based on Article 595. As seen, you can see in the screen, it's about the Article 595. Open situation the rule or directly in the say collective or himself, but not but to take action let them make them to be rooted. Situation whether whether the damage has been of Thầy không nghe thấy quen không? Ờ, Thầy ơi,
I will continue on because she has some problem with her computer. So we can say that the regulation of liability to compensate for damage caused by exceeding the requirements of the urgent situation and requirements of the urgent situation is also based on four conditions that give rise to the compensation liability. The purpose of the act of causing damage is to protect other interests. The damage caused must be within the time the risk exists and directly threaten the interests that need to be protected. Causing damage must be the last and only choice, and finally, the damage caused must be smaller than the damage should be prevented. If causing damage meets all four requirements, it is considered causing damage in accordance with the requirements of the urgent situation, and therefore, the person causing the damage does not have to compensate. On the contrary, if one of the above four requirements is missing, is it considered to cause damage due to exceeding the requirements of the urgent situation, and person causing the damage must be compensated. And now we move to China. According to the compensation law of People Republic of China, Article 31, where any harm is caused by any conduct of necessity, the person causing the occurrence of danger should be liable. If the danger is as a result of a natural cause, the person causing the harm for necessity should not be liable for also make proper compensation. If improper measures of necessity are taken or a necessary limit is exceeded, causing any undue harm, the person causing the harm for necessity should assume proper liability. It can be seen from the above regulation. First, the necessary harm. This means that only when the harm is necessary will be the person causing the harm be held responsible. This apply in reasonable case such as auto-protection, self-protection, or any other case where there is necessity interest. Second, danger due to natural causes. If the danger occurs due to natural causes, that are not related to the action of the person causing the danger, the person causing the harm is not responsible or must only pay appropriate compensation. This suggests a distinction between the liability of harm thus in cases of reasonable danger resulting from their conduct and cases of danger not due to their conduct, and finally applying measures that are necessary if the person causing the danger applies excessive protective measures or seeks the necessary limits and causes unnecessary damage. The person causing the damage will be responsible legal. This refers to person causing the danger as must be accompanied by rules and regulation regarding the use of necessary measures to avoid causing unnecessary harm. And also, and now we will move to Germany. Version to German civil court. If according to section 253 with non-material damage, if individual with first, for damage that are not financial losses, monetary compensation can only be claimed in cases prescribed by law. And second, if compensation is due for injury to body, health, sexual freedom, or self-determination, monetary compensation may also be fairly claimed for damages other than lost finance. Besides that, based on section 228 of emergency stipulated in German civil code, anyone who damaged or destroyed the property of another person in order to prevent a threat to themselves or others is not unlawful if the damage or destruction is necessary to prevent the danger, and the damage is disproportionate to the degree of the danger. If the person causing danger must be responsible for compensation, we can understand that anyone, if in an emergency is dangerous to safety, may use reasonable and necessary measures of self-defense or self-protection, including damage or destruction of property of other. However, based on section 2300 of the German Civil Code, exceeding the emergency situation must still be within the following limits. First, self-reliance should not exceed what is necessary to prevent danger. This reflects the general principle in the law that self-defense is only permitted to the extent necessary and proportional. Second, relocation of objects and request for property confiscation. In the case of relocation of objects, if there is no compulsory enforcement measure or request for confiscation of property, it is necessary to file a request for confiscation of property. Third, arrest the illegal and request to file an application in court. In case of arrest of the illegal, the personal security arrest must be filed in the local court and the obligor must be brought before the court without delay. And finally, delay or refuse of application for seizure and return of objects. If the application for arrest is delayed or refused, the item taken must be returned and person arrest must be released immediately. So we can compare three countries together. In Vietnamese civil court, the provision of compensation for damages due to exceeding an urgent situation is based on four conditions that give rise to compensation liability. The purpose of act, or causing damage is to protect all the interests. Second, the damage caused must be during the time the risk occurs and directly threaten the interest to be protected. Thirdly, causing damage must be the last and only option. And finally, the damage causes must be smaller than the damage that can be presented. And if that four conditions are not met, the person causing the damage must compensate. In China, compensation for damages is only determined based on the factor that if the person using the necessary measures use it for the wrong purpose or exceed the necessary scope, leading to unnecessary damage to others, they will be responsible for compensation for such damage. Question to the German civil court: if an individual or entire causes damage to another person through a wrongful act or omission, they are liable to compensate for damage. However, the provision of compensation for damages due to urgent situations in Germany is not clearly stipulated in the civil court. But based on the section 228 of this code, anyone in an emergency dangerous to safety their lives, they may also use reasonable and necessary measures to of self-defense or self-protection, including damage or destruction of property or of other in version to clause 1, section